Hey everyone. So if you're in a sport management program, you know you're learning to manage a business. But what's the single most valuable asset of that business? You might think it's the stadium or maybe the star player. Nope, it's the brand. And the legal shield that protects that brand is trademark law. Today, we're going to break down exactly how that shield works and why knowing this stuff is absolutely crucial for your career. So let's just dive right in with the big question. When you see a team's logo or just a simple swoosh, what gives it so much power? How is it worth billions of dollars? It's definitely not just some ink on a jersey, right? The real answer is in the legal framework that protects it, turning a simple little graphic into a massive billion-dollar asset. And this really gets to the heart of it. A trademark is so much more than a logo. It's basically a promise. It's a symbol of identity, a guarantee of a certain quality. For us as fans, it's the mental shortcut we use to decide what to buy. That instant recognition, that trust, that's where the value really comes from. All right, so to make sure we're all on the same page, let's just lock in the official definition. A trademark can be a word, a name, a symbol, like the Yankees interlocking NY, or pretty much any device that does one key job. It tells you who's behind that product. Okay, so you've got this awesome, powerful mark. Now what? How do you actually protect it? It doesn't just happen automatically. There's a very specific rule book you have to follow to make it official and legally defensible. So let's walk through those rules. Now, here's a really interesting little distinction. We tend to use the word trademark for, well, everything. But technically, a trademark is for physical goods, the jerseys, the hats, the equipment. A service mark, on the other hand, is for services. Think about the Super Bowl broadcast or the experience of going to the Olympics. It's the same core idea, just a different application. And then there's a third category you will see all the time in sports, the collective mark. This one isn't about a single company. It's about showing you're a member of a group. And the perfect example, of course, is the NCAA logo. When you see that on a stadium or a jersey, it tells you that school is part of the association and plays by its rules. So the most important point here is that protection requires you to take action. First, you register your mark with the US Patent and Trademark Office. That gives you the strongest legal rights possible. Second, it's not a one-and-done deal. You have to renew it every 10 years. And third, and this is so important, you have to actually use the mark out in the real world. It really is a use it or lose it kind of system. But, and this is a big but, there are limits. You can't just trademark any old word. You can't claim a generic term. If a word just becomes the common name for the product itself, think escalator or aspirin, which were both brand names once, it can lose its protection. A brand like Kleenex has to fight constantly to make sure people see it as a brand, not just the name for the product. Okay, so your mark is registered, it's protected. Now the real game begins, defending it. This brings us to the main conflict in all of trademark law, infringement. So what actually happens when someone else steps on your turf?
Here's the legal definition, but I want you to zero in on one key phrase, likely to cause confusion. The entire legal battle hinges on this question. Would an average person be confused or tricked or mistaken about who actually made this thing? If the answer is yes, you've probably got an infringement case.
So when a case goes to court, think of it like an official review in a game. The judges have a checklist. They look at things like how strong and unique the original mark is, how similar the two marks look, and this is a big one, if there's any proof that people were actually confused. The other guy's intent matters a lot too. As a manager, your legal team is building its whole case around these points. Now, infringement can sometimes be an honest mistake. Counterfeiting, oh no, that is a deliberate, intentional act of piracy. We're talking about someone making fake jerseys or hats that are specifically designed to fool people into thinking they're the real deal. This is a massive problem in sports, and the law takes it very, very seriously. But like any good legal drama, it's not always a simple case of you used my logo, you're in trouble. The law has a lot of nuance, and there are several well-established legal defenses that someone can use to argue their use was okay. Let's check out these exceptions to the rule. Here are some of the most common arguments you'll see. If you get accused of infringement, your lawyer might say the original owner abandoned the mark or that they waited way too long to sue. That one's called laches. Or you could claim that what you did was fair use or even a parody. Let's break a couple of these down. Remember that use it or lose it rule we talked about? Well, this is the lose it part. If a team or a company doesn't use their trademark for 3 straight years, the law just assumes it's been abandoned. This actually happened in a famous case with the Baltimore Colts name after the team snuck off to Indianapolis. Because the name was abandoned, a new team in Baltimore was eventually able to use it. The defense of latches is all about timing. It basically means you can't sit on your rights forever and then decide to sue years later. This quote from the Fitbug versus Fitbit case says it all. The plaintiff knew about the issue for over 4 years before they did anything. The court said nope, that's not a reasonable delay, and it cost them the case. The takeaway is you have to defend your mark, and you have to do it in a timely way. Now, fair use and parody are two defenses that are all about free speech. Fair use lets you use a trademark for things like news reporting or, say, comparative advertising. Like a Pepsi ad showing a taste test with Coke. Parody is a little different. It lets you use a mark to make a joke or a social comment, like a funny sketch on Saturday Night Live that makes fun of a team's logo. All right, let's talk about a fascinating and pretty recent earthquake in trademark law. For decades, the main trademark law in the U.S., the Lanham Act, had a rule saying you could not register marks that were considered disparaging. But in 2017, the Supreme Court took a hard look at this rule and completely flipped the script. The case was called Mattel v. Tam, and the Supreme Court's ruling was unanimous. They said that denying a trademark just because the government thinks it's disparaging is a violation of the First Amendment. The government can't deny a legal benefit based on the viewpoint of the message. And this legal earthquake sent immediate shockwaves right into the world of sports. And here's the real-world impact. For years, there was a huge legal battle to cancel the trademark for the Washington Redskins based on the argument that the name was disparaging. Well, after that Supreme Court decision, that legal argument completely evaporated. The case was effectively over. It shows that while the team did eventually change its name because of public pressure and sponsors, the legal path to force the change through trademark law had been shut down. That brings us right up to the modern era. The principles we've been talking about are timeless, but the playing field itself is constantly changing, especially online. So let's look at a couple of key digital challenges that you will absolutely have to deal with as a sport manager. First up, cyber squatting. This is when someone goes out and registers a domain name, like, say, NewYorkYankeesMerch.com, not because they're a fan, but with the bad faith intent to hold it hostage and sell it back to the team for a huge profit. Congress actually had to pass a specific law, the Anti-Cyber Squatting Consumer Protection Act, just to fight this. Another modern problem is ambush marketing. This is when a company that is not an official sponsor, let's say for the World Cup, runs a bunch of ads that cleverly make you think they're associated with the event. They're trying to piggyback on the excitement and goodwill of the event without paying those massive sponsorship fees. And that leaves us right here, looking at what's next. The fight to protect a brand's identity, it never really ends. As we move into a future with AI-generated content, VR stadiums, and a totally global digital world, the challenges are only going to get more complicated. So the question for you as the next generation of sport managers is this: what's the next big threat to a brand, and how will the law have to change to keep up?